Chief Executive Officer Brad Garlinghouse and Executive Chairman Chris Larson of Ripple have been cleared of charges in a case involving securities violations involving XRP transfers. The Securities and Exchange Commission made the choice to drop the charges. Reports say that the Securities and Exchange Commission has decided not to look into the claims. Concerning this specific legal matter, the Securities and Exchange Commission of the United States of America has already named the people who are facing legal action because of the decision that was made and the events that followed. The case is now getting closer to a first conclusion, and there may even be a chance to appeal the decision. The reason for this is that the choice was made and the events that followed. Because of the ongoing debate between the cryptocurrency business and the Securities and Exchange Commission over what a security really is, this decision was made. The argumentative discussion has been going on for a long time. People say that Brad Garlinghouse, who is the CEO of Ripple, and Chris Larson, who is the executive chairman of the company, broke federal securities laws when they did business using XRP. After giving it a lot of thought, the Securities and Exchange Commission has decided to end its review into the claims that have been made. Because of the choice that was made, the hearing that was supposed to happen next year would not happen the way they had planned it at first. In addition, the cryptocurrency company will win yet another case that the government is currently seeking against it. This action is happening now. Because of this, the governing body will be one step closer to reviewing a decision made by a federal court in the Bitcoin business case. Everyone decided that the claims of helping and abetting against the two executives would be thrown out without further action. This is an agreement that was reached between the two sides. This kind of withdrawal would happen under these conditions and have no effects at all. Taking into account what this study found, it is possible to say that the accusations will never be brought up again. Over the past 3 years, the Securities and Exchange Commission has been paying close attention to Ripple. During that time, it has been investigating the cryptocurrency, and in July, it filed charges against it. It was decided by a court that Ripple had not broken any federal securities rules when it put XRP on exchanges so that private investors could buy it. The court came up with this choice. This is what the court decided when it gave its ruling. The court came to this conclusion after the ruling was made, no matter what the case is. Even though this was only a partial success, that doesn't change the fact that it was still a big win for Ripple. It's true, even though it was only partly successful. The charges that were dropped had to do with the sales to institutions that were set to be tried in April of the next year. The charges were dropped, though. The charges, on the other hand, were dropped. These charges were dropped, which made it possible for this friendship to start, which was a big chance. Information about the deal was called a surrender, and Ripple put out a news release about it on their website. The company was in charge of getting the news statement out there. The government worker from the Securities and Exchange Commission refused to say anything about what happened. There have been reviews by the Securities and Exchange Commission into cryptocurrency companies that the SEC thinks break securities laws. These companies were chosen to be looked into more closely, and the investigation has been going on for a while now, even though the SEC has had to deal with a number of court problems. The head of the Securities and Exchange Commission, Gary Gensler, says that almost all cryptocurrencies should be seen as securities that come under the agency's control. This is what Gensler said. This thing Gensler said was made public. The US courts have made it clear more than once that this is not a true reflection of the situation. A statement from the company says that about 90% of Ripple's work is now done in countries other than the United States. Ripple Labs and the US Securities and Exchange Commission are currently in court fighting over the last parts of their case. This is what Ripple has asked the court for. The court should order the company to share its financial information for 2022 and 2023 under contracts that cover institutional sales. This request is part of the case that the company is making to the court right now as part of its appeal. The Securities and Exchange Commission filed the first complaint in December 2020, and these comments were made after the case was filed. The lawyers for the Securities and Exchange Commission have also asked Ripple to make public the exact amount of money that was received from sales to institutions. According to Ripple, this request is pointless and has nothing to do with the talk going on right now. It has been said by the Securities and Exchange Commission that the discovery window is still open, even though the Supreme Court made its decision in November. This decision said that until February 12, 2024, remedies related to discovery would be possible. The SEC has said that the discovery window is still open for this ruling. Because the SEC complaint was filed, the agency has decided that these papers are relevant to find out if Ripple did any more violations after the complaint was filed. In a summary judgment, the judge in charge, Melissa Torres, said that the program token issuance of XRP by the business did not meet the criteria for being considered a security. This was seen as a partial win for Ripple. This was a win for Ripple in some ways. Ripple was able to reach a certain amount of success with this project, The Securities and Exchange Commission looked into the company's sales of XRP to institutional investors and decided that they would be seen as releasing securities that were disguised. After looking into it, the SEC came to this decision. This happened because Robert Garlinghouse, the CEO of Ripple, had put more than $150 million into security. As long as both sides agree on the remedies for the discovery issues and the court can stick to the schedule it set out at the beginning, the Securities and Exchange Commission has until March 13, 2024, to present its remedies brief. That's the last day the court has given Ripple to say anything about the issues that have been brought up. A month has been given for them to think about the many options they have. On Thursday, the U.S. Securities and Exchange Commission chose to drop the charges that it had previously brought against two executives of Ripple Labs. The claims were made public in September. There were legal actions taken against the blockchain company by the Securities and Exchange Commission. The SEC said the company had broken rules about securities in the U.S. According to court records, the government has dropped its claims that Brad Garlinghouse, CEO of Ripple, and Chris Larson, co-founder of the company, encouraged and pushed the sale of the cryptocurrency XRP. These claims were seen as unregistered securities transactions by the government. It was also ruled by the court that the deals cannot be registered as securities. Unregistered securities trades are things that can be done with securities that don't need to be registered. After much thought, the court has decided that these deals should not be. The fact that the government is dropping these hints is a strong sign that it is showing strong signs that it is no longer supporting these claims.